Hello. In this clip from our Justia webinar, Advising on AI, Guiding Your Clients Through AI Challenges, James Scotto gives an overview of the challenges of using AI within the legal industry, including inputs, outputs, liability, and indemnity. Remember, if you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Thank you very much. Welcome, everybody. A pleasure to be here today and to talk to you about some of the thorny issues with AI and really how to navigate them and manage the risk as you and clients use your AI tools. So without further ado, let me jump into this. Nina did my background, so I'll skip over that. Just a brief overview of what we're going to cover today. Primarily AI legal issues, some policy issues, and then really a lot on risk management. There's many pending lawsuits where there's unresolved legal issues relating to AI, a number of regulatory enforcements. We'll talk about some of those. We'll talk about the current U.S. AI policy, primarily as set forth in the White House Executive Order on AI, and some of the recently passed and pending legislation relating to AI. And then we'll talk about how to manage the legal risks. Okay. So the first thing to understand is that legal issues with AI vary based on a number of factors. And at a minimum, they factor based on the company's role with AI, the tools they use, how they use them, among other things. So what do I mean by the roles that a company plays with AI? Within the AI ecosystem, there's many different players that provide different aspects of what goes into making AI. Then there's companies that use AI. So for example, in order to have an AI application, you have to do what's called training an AI model. This requires a lot of data. There's some companies that are just harvesting and mining data and licensing it to other companies. There's other companies that are sitting on a lot of data just based on their existing business model, and they're using that to license data. We've seen some big media companies license to some of the big AI companies. Those are examples of data providers. Then there's the companies that are training AI models. And then there's companies that are developing tools that use the AI models. And in some cases, companies play more than one of these roles. So a company may collect their own data, train the AI, and develop tools. In some cases, that may be fragmented. Then you have companies that are deploying or using AI tools. And then you have companies that are modifying or enhancing third-party models that have been trained through processes called fine-tuning or RAGs, which is retrieval augmented generation. And lastly, in some cases, companies just use content that's generated by third parties. So just like companies hire third parties to develop software or create imagery for marketing, et cetera, sometimes companies will just rely on third parties who are using some of these tools to create the content. So these are some of the types of roles. There's others, but depending on what the company does, their legal issues and their risk profile may vary. We'll talk about that as we get into it. As far as tools, there's many different AI tools, new ones popping up every day, but at a high level, one of the things that's really kind of been prevalent is content generators through what's referred to as generative AI tools. So these are tools that can create pictures, movies, songs, text, all types of creative content. We see a lot of chatbots that are used to interface with customers or consumers that try to provide relevant information to consumers in a natural language type way without having humans in the loop in many cases. There's AI code generators. Almost all developers now are already adopting these AI code generators. These are AI tools that assist developers in writing code. They literally will auto-complete lines of code. In some cases, it'll check the syntax and check for errors in code. And in some cases, developers can just ask the tool to provide a chunk of code. For example, it may say, I need a calculator function in this application, and it'll create code that would create a calculator function. Then there's other tools that are of significant regulatory concern, and these are typically deemed to be what's called high-risk decision tools. In many cases, and we'll cover this a little bit more, these are typically things that have and impactful, that these are tools that create or assist in rendering decisions that can have an impact on consumers, patients, in lending situations, your borrowers, students, as far as decisions getting into school, anything that can impact a person. Many of these tools are deemed to be high-risk decision tools. Those are some of the ones that have been more thoroughly regulated, and we'll talk about those a little bit more in detail. And then the uses, the way companies are using the content vary as well. You can see here various examples, and I won't go through them. You're probably familiar with many of these, but depending on the types of content that a company is generating and what they do with it may have an impact on what the legal issues are. So the only reason I go through this is to say there's not like a one-size-fits-all that applies to all companies here. You really need to understand, if you're advising a company, what are they doing with AI and how are they using it and what tools are they using? Okay, I'm going to go through at a high level some of the key legal issues. I'm going to drill down on some of those in more detail. You'll see here on most of these, I've got a link to either articles or blog posts or some other content that goes deeper into these topics. But one of the things we needed to understand is what's called algorithmic disgorgement. This is a penalty that can arise from improperly training AI on data that you don't have a right to use for training AI. I'm going to give you an example of that in a second. But the impact of this, and one of the reasons I put this first, is that it's very expensive to train AI. The result of algorithmic disgorgement, if a company is faced with that, is they have to delete the AI model and anything derived from it. So it kind of wipes out an entire investment. So obviously that's one of the things you want to avoid. On the copyright and IP side, it's important to understand the Copyright Office has issued guidance and decisions, and there's been some court cases that have upheld this, that the output of generative AI is typically not protectable by copyright because it's not human authored. We'll touch on that a little bit more detail as well. So it's important to understand that if a company wants to create content or have content created for it by a third party, for example, that they want copyright protection for, using generative AI is maybe a problem. One of the things we're seeing pervasively throughout every company is that employees are using AI. And in many cases, if companies haven't adopted a policy on AI use, employees are just using the tools they want to use without understanding the legal risks that come along with it. We'll cover some of these in more detail, but some of the things where there's been actual issues already is companies will use a public generative AI tool and put in confidential information. There was an example of an employee who had put in confidential information about a new business plan that a company was adopting and asked the tool to draft a business plan based on the information that was put in. The information put in was confidential. It later got output to another company, and that the confidentiality was lost. There's a lot of issues in understanding that the inputs to and outputs from AI that a company provides, in some cases, you're actually licensing that back to the tool provider so they can use your inputs to retrain the AI models to make them better. There's risk with that. Indemnity is a big issue. There's a lot of potential issues with these tools. There's going to be infringing output, other types of things. It's important to understand that with some of these tools, you are actually indemnifying the tool provider. They're not indemnifying you. And so some of the tools that have those types of terms, many companies won't approve, but employees, if there's no policy, are using it not understanding that that's what the legal situation is. Those are just a few examples. We'll cover some more later. As I mentioned earlier, AI code generators are very powerful tools that their developers are getting a significant increase in productivity using these tools, but they're trained on open source software typically. And for those of you who are familiar with open source, most companies have an open source policy for managing open source. Using AI code generators raises new issues, and we'll cover that as well. There's a lot that goes into training AI models and building AI tools. And you may hear the term responsible AI development. That simple word has a lot of complexity behind it. There is a lot of things that need to go into ensuring a AI tool is responsibly developed. It needs to be, you need to ensure that it's tested so that you minimize the inaccuracy in the outputs. You need to ensure that it's trained on sufficiently representative data, that the outputs don't create biased or discriminatory results. And there's many other issues as well. We'll touch on some of those. One of the things that's important, as we'll see in managing risk, is to develop policies, as I alluded to. And part of the policies typically involve deciding on a company-by-company basis which tools the company will permit their employees to use and which versions of those tools. As we'll see, the same tool may have different versions and the legal terms may differ. We'll talk about some examples there. But for these and other reasons, it's important when companies are deciding whether to use a tool, just like you do vendor diligence for any technology you adopt. You need to do all of that with AI, but there's additional issues that are unique to AI that require enhanced vendor diligence. And we'll talk about that as well. There's a number of state laws that have passed. There's not that many new laws actually that have passed on that are AI specific, but the number of laws will be increasing. There's a lot that are pending. California, Utah, Colorado have passed laws. Some of the laws have simple disclosure requirements. For example, under Utah, if you're using an AI chatbot to interact with a consumer, you need to disclose that up front so the consumer knows they're not talking to a real person. Colorado law has pretty comprehensive consumer protection with respect to AI, and it doesn't come into effect until February 2026, but it imposes obligations on both developers and deployers, meaning users of AI tools. And then internationally, I'm not going to go into it very much, but probably one of the most significant pieces of legislation that's passed is the EU AI Act. And it's important to understand that while it's the EU AI Act, it may have extraterritorial effects. So even if you are building AI here, if it's going to be used or deployed, for example, in Europe or in other circumstances, the EU AI Act may apply to you as well. So these are just some of the issues. We're going to go into more detail. Let's focus on the IP side first. As I mentioned, Copyright Office has issued guidance. There's a link there to it. And as I said earlier, basically, the output of generative AI is typically not protectable. Under the copyright law, only human-authored material can be protected. So if something is output from generative AI, it's not protectable. Now, some people say, well, if a human provided the prompt and the idea for the output, is that sufficient? And the answer is no, because ideas are not protectable under copyright. The actual creation of the content is being done by the AI tool, according to the Copyright Office, so you can't protect it. Doesn't mean there's no copyright available. Generative AI may be part of a work that's human authored, and you can get protection for the work as long as there's human authorship. You have to disclaim protection for any portion that is AI generated. Same on the patent side. So you can patent AI technology just like any other technology. The law is the same. There's no different rule. In fact, roughly 20% of all the patent filings this last year or so are AI related. A very significant percentage of patents that are being filed are somehow related to AI, and they're being issued. You can use AI. The Patent Office just issued guidance. You can use AI to assist in generating inventions, but there's a test that goes along with this, and the test really focuses on, is there significant human contribution to the invention? Won't get into a debate about whether AI can invent things or not. Short answer is it can. A lot of people don't believe that, but there's been patent applications filed where AI has been listed as an inventor, and the Patent Office will not grant those patents because you can't list a non-human as an inventor. So if something is purely AI invented, it's not going to be patentable. Those are some of the highlights there. Inputs and outputs. So the inputs, if any of you have used, I'm sure most of you use generative AI, whatever you type into the AI as a prompt or an input, it's important, as I mentioned, to make sure that you understand what that tool is doing with those prompts. In some cases, in the more desirable cases, it takes your prompt, it processes it, it generates the output you're looking for, and it deletes the input prompt, and it doesn't retain it, and it doesn't use it for other purposes. But in other cases, some of these tools will actually retain the prompts and the outputs and use it to retrain the tools to make them better over time. How do you know whether it's doing that or not? There's a couple of levels. One is typically companies will disclose in their marketing or product description what they're doing. Second, you'll typically, even if you don't see it there, it'll typically be in the terms of service, because most of the companies that are using the content will, in the terms of service, say you are granting a license to the tool provider to use your inputs and outputs. So you're granting an express license by accepting the terms. And this is an important thing when it comes to employees that are using tools without understanding this. In many cases, there are free versions and there's enterprise versions of the same tool. And the free version often will have a license back to the tool provider, whereas the enterprise version won't. So this is one simple example of a criteria that as a company, if you're going to adopt a tool, you're typically going to want to use the enterprise version and ensure that your inputs and outputs are not reused. Okay, on the liability side, who's liable if the output of generative AI tool infringes? Is it the tool provider or is it the user? Short answer, it could be either or both. If the tool provider is using copyrighted content, for example, to generate content, they may be creating an unauthorized derivative work, or they may be substantially copying the material that the AI was trained on in producing an output. As a user, if you get an output and you publish it or you make copies of it, if it's infringing, you may be liable as well. So there's potential liability to both parties. And so in some cases, it's very important to think about the indemnity provisions of these tools. And just like with the confidentiality provisions I mentioned earlier, some of the free versions of the tools, the terms or legal terms are not very favorable. So for example, the user indemnifies the tool provider if the output infringes. With the enterprise versions, typically the tool provider will provide an indemnity to the user. It's important to understand, though, that even the tools that provide indemnities, some of them have preconditions. So for example, with Microsoft Copilot, they do provide indemnity if the output infringes, but the preconditions are they have a set of what they call guardrails that you have to implement, which minimize the likelihood of infringement. So there's certain things you have to do with the inputs and metadata, and there's a link on their site that you can see of what's there. But the point is, and it varies by tool, but it's important to understand that even if there's indemnity, it may not automatically apply. And with Microsoft, they make it very clear that if you seek indemnity, the first thing they're going to ask you is to establish, and the burden's on you, according to them, to establish that you met the preconditions. And if you haven't met the preconditions, they're going to deny the claim. Okay. This is just a little bit more on that. I won't go in this in great detail. I covered it at a high level, but this just is kind of a takeaway for you as you kind of review the deck later on. You see the guardrails and mitigations that we talk about here. Okay. Chatbots. Chatbots are a very popular tool. They cover a wide range of types of things. Some of it can just be text in and text out, where you're asking questions and it provides answers. In some cases, you may provide a text input and ask for something else to come out, like images, whatever. There can be various forms of chatbots. But what's important to understand is that, as I mentioned, like with Utah, and we're seeing in some other pending legislation, there's going to be a requirement typically to disclose that that a person is interacting with a chatbot and not with a human. There's a whole set of issues that can arise with respect to recording of chatbot conversations, and it could get into some of the wiretapping laws. So it could be civil and criminal penalties if you violate these. This varies by state. When it comes to recording of conversations, some states are a single party consent, some are dual party, meaning one party, if one party consents to recording, it's sufficient. And so if you're a party to a conversation, you can consent to it. Some states, both parties have to consent. So it's important to look at this on a state-by-state basis and make sure you understand which laws here apply if you're recording. Now, there's another thing before I move on that's important to understand, is that there's a lot of third-party tools that companies are using to do recording for them. And one of the things that's important to understand is that the tool is not a party to the conversation. It's the individuals, like if it's company A and company B, or company A and a consumer. If the recording is going to and being used by the third party tool provider, in addition to you as the company that's using the tool, that may be illegal as well and create other issues. So this is it's an evolving area, and I think it's one to watch, because chatbots are being used by many consumer brands to work with, kind of help customers, and there's a value to them, but there's these tricky issues you need to navigate. On the AI code generators I mentioned earlier, so the way these work is typically these AI models that are designed for AI code generators, they're trained on open source repositories. And for those of you who play with open source, typically if a developer wants to use an open source component, they know which component they want. They do research on what the functionality is. They decide they want to use this component. So they know they're using an open source component. And most companies have an open source policy that says, you have to, review the license that covers the open source and make sure there's no provisions that violate the company's open source policies. Okay, so that's all fine. The problem with AI code generators is that the developers typically do not know if the output that they're getting from one of these is based on open source or if it was generated by the tool itself. And so this creates a complexity in managing open source if what is output to a developer and used is covered by or based on open source. So one of the things that's really important is for companies to update their open source policies to provide guidance to take into account these open source tools. And again, these tools work in different ways. Many companies will approve certain tools depending on their terms and their operation, et cetera. So I'm not going to say, here's what you have to do or not do, but it depends on the tools that you approve. But what companies have to do is address this and update it, because all developers are starting to use these tools. Many are using it very prolifically. You can see on the right kind of some of the level of efficiency that developers are getting with this. So it's beneficial to let them use it, but you have to manage the legal risk by updating the policy. The couple of articles there on the slide that I've prepared on this that go into more detail. Okay, so I mentioned earlier high-risk decisions. Some of the areas where we've seen activity already is in connection with AI used in connection with employment decisions. So the EEOC issued guidance, which is provided here as a link to the document. And in September of last year was their first AI-based enforcement. And there was a company that was using a third-party tool. The company was iTutor Group. They were using a third-party tool to screen applicants, potential employee applicants. And it turns out that the tool was biased in that it rejected applicants that were over a certain age. And this came to light, and the EEOC did enforcement against the company. And, part of what the company tried to argue was that, hey, we're just using a third-party tool. We didn't build it. The EEOC and other agencies have made clear that liability for harm that results from these tools rests with the developer and the deployer in many cases. So if you're using the tool and there's a problem, you have a legal problem. And so this is one of the reasons why it's important for companies to both do vendor diligence, as I mentioned earlier, to understand how these tools work, how they were trained, and I'll go into the vendor diligence a little bit more detail later. But you need to do this type of diligence to avoid unnecessary liability, or if there's tools that don't meet the criteria that you establish for the AI component of the vendor diligence, you should just not approve the tools. That's kind of how companies are doing it now. And for the tools that are running into this problem where companies aren't using it, they either adapt or they perish, right? If companies are doing diligence and their same issues are coming up, they need to go back to the drawing board and redo their tools if they want people to adopt them. Now, some people will use the tools without doing the diligence, but over time the information gets out that these tools have certain problems. So that is a really important reason to do the vendor diligence. Okay. There's a number of laws that have been passed. In fact, New York City was actually one of the first to pass a law that has certain notice requirements that if you're an employer and you're using an AI tool to screen applicants or in connection with employment decisions, you need to provide notice. You need to give them an opportunity to opt out. And there's a requirement before you use the tools that you have to have an audit done to ensure the tool doesn't have any bias. There's third parties that will do audits if you don't have the internal capability to do it. But that's one of the requirements under New York City law, is that you do that before you deploy one of these tools. So again, that's part of the vendor diligence is doing an audit like that. But that's legally mandated if you're operating in New York City. New York State has law. We're seeing more and more states proposing and or passing, will likely soon be passing laws relating to AI-based employment decisions. And in many cases, the employment decision is not just the hiring decision, not just hiring somebody, but if AI is used in decisions for promotions, bonuses, raises, firing decisions, employment decisions cover pretty much the whole, can cover the whole life cycle of decisions, not just the hiring piece.
Thanks for watching. We hope you enjoyed this video. If you enjoyed it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.